Okay. Welcome everyone. Thanks. A big welcome to all of you, and thanks for being here during the kind of nail-biting situation that we are seeing happening outside. We're all waiting to hear how it's going to go. So thanks. I think the fact that all of you are here means a lot, and it also means that we take it to mean that what we are discussing here is actually really vital, given the situation that we can see outside. So this event is on from the climate cases to the International Court's advisory opinion, the key role of courts. We have an incredible lineup of speakers. The event is organized by the Center for International Environmental Law, by WALHI, Friends of the Earth Indonesia, Friends of the Earth International, the Center for Environmental Justice, and the European Center for Constitutional and Human Rights. I will introduce our incredible lineup of speakers who all are involved with different kinds of cases on the ground. We have Nikki Risch from the Center of International Environmental Law, Agus Dwi Hastutik Walhi from Friends of the Earth Indonesia, Nina De Pater from Milieu Defensie, Friends of the Earth Netherlands, and Jule Schackenberg from the World Youth for Climate Justice. And they can say a bit about their role when they speak. I'm Kirtana Chandrasekharan, and I'm from Friends of the Earth International, and I will try my best to chair our extraordinary panel, and I don't think they need it. But I just want to open by saying a bit, which I think will be echoed, which is that, we know that the climate change is it's an existential threat, and it really has extraordinary risks. They're very well established and very well visible all over the world, whether that's temperature rising, heat waves, the storm intensifications of storms, ocean acidification. I mean, there's a huge variety and very deep amount of evidence and science and actually empirical impacts that communities are facing that we know. But despite this, and scientific consensus on the causes and the risks of the climate crisis, and the fact that actually many of the real solutions are being practiced and demanded for by all the civil society organizations and movements on the ground, the progress towards tackling this is quite appallingly slow and inadequate, as I'm sure most of you will agree. And so one of the tools that all our organizations are deploying increasingly, and also communities on the ground, is climate litigation. It is expanding across, although there are national legal jurisdictions, but there are lots of precedents being set. It's very exciting. And globally, we can see that the number of climate cases is doubling. And there's, I think, about 2,000, close to maybe over by now, 2,000 cases across the world. So our speakers will be talking about the key role of the courts, some groundbreaking cases, and also the overall situation and the importance of that. So without further ado, I want to pass to Nikki Risch, who's the director of the Climate and Energy Program at the Center for International Environmental Law, where she leads a team of attorneys, campaigners, and researchers driving legal and policy change to address the causes and consequences of climate change and the responses to it. Nikki.
Thanks so much, and thanks to all of you for being here, and thanks to the co-panelists. Maybe if we can advance the slides, just one, or if I can have the clicker, thank you. If technology is my friend, that's my name. So as Kirtana said, I was just going to start out by putting this discussion a little bit in context and emphasizing how significant and how important, from a change perspective, the rising tide of climate litigation is. We say that as temperatures and sea levels rise, so too do demands for climate action and climate justice. And we are truly living in a historic time. We are witnessing, and have been for several years, a rapid proliferation of the number of climate cases around the world. And I don't think this map fully does it justice. This is from a recent snapshot of climate litigation of different types. But what we see is that there are cases being brought around the world by different categories of plaintiffs under different legal systems and theories against different and diverse defendants. And those suits, many of which are about pushing governments and companies to be more ambitious, to do more on climate under a variety of legal duties, under their human rights and constitutional duties, under tort law, under longstanding environmental law, and of course, under their obligations within the convention that the parties are here speaking about. And it's no surprise, really, that we're seeing this rapid increase in litigation because as the crisis escalates and as action to resolve it lags so far behind, as we're seeing here in these halls, we are seeing communities and now indeed countries themselves turning to courts for justice and accountability and really demanding clarification of what the law requires. And it's only natural, that's what people have always done when they're harmed and they're not getting remedy, is turn to courts to demand justice. So what's significant about the fact that there are so many different types of cases and theories that are being advanced is that this is not something that is going to taper off quickly. There's no, whatever is decided here in these halls, the states and companies that they have a duty to regulate are going to return home and be subject to the legal obligations that long predated this regime and that continue to apply and bind them alongside it. And so this climate litigation isn't about making new law all the time. It's about applying long-standing existing legal obligations in the context of a rapidly escalating emergency. And in this factual context where the science is undisputed, we know the causes of climate change and we know the consequences. In fact, this isn't a whodunit. The evidence points clearly, we know the fossil fuels and the fossil fuel industry bear the greatest responsibility for contributing to the harm. And we know what is necessary to prevent and avoid future harm. We also know which countries bear the largest cumulative responsibility for the crisis around the world. And in that context, it is no longer just morally unacceptable, but it is legally impermissible to continue business as usual and not to pay up for the reparations that are due for the mounting climate harm. So I just wanted to mention a few of the key landmark decisions. We're living in this historic time, not only because of what's happening around us in these halls and some might say the breakdown and stagnation of these talks, but because people are pursuing really remarkable cases and they're winning in many instances. And this is just to highlight just a few of the recent wins just this year alone that really are markers of progress around climate litigation and accountability. And so we saw earlier this year in April, the first decision by the European Court of Human Rights in a climate case, in the case of the Swiss senior women against Switzerland. And this case was historic because it was the first time an international court recognized, number one, that the climate crisis is a human rights crisis, uncontestably, and that when states take inadequate action to tackle the drivers of climate change to reduce greenhouse gas emissions rapidly and effectively in line with science, they violate their human rights obligations. They violate the rights of the population. And that decision is significant and sends a signal to national courts around the world, to advocates, and isn't just important for Switzerland, which was bound by the decision directly. It's important for all 46 members of the Council of Europe who are equally bound by the same underlying legal obligation in the European Convention of Human Rights. And it has ripple effects beyond that, because the fundamental human rights underpinning the decision, the right to private and family life, which includes the right to health, that right inures to everyone around the world and is enshrined in many other human rights laws and constitutions. And so it sends a signal that other governments too, unless they align their climate action with what science shows is clearly required and what justice demands, that they too may face legal consequences. As some of you may have heard, there has been backlash and pushback from Switzerland to this judgment, but I think that's really a testament to the efficacy and the importance of these lawsuits. Unable to win on the facts and the law, we're seeing governments and companies attack the institutions themselves, attack the courts that are issuing these judgments and the people who are turning to them. And I think that really underscores the importance of protecting those institutions and protecting the rights of those who use them. Excuse me. I just wanted to highlight two other key cases to show a bit the diversity. So that was a case against a government for insufficiently ambitious climate action, something that's on full display here in these halls with us. But there are also cases that are taking on not just the ways in which states are not doing enough to tackle the climate crisis, but the ways in which they're actually contributing to making it worse. And so there was a case in the UK in June where the Supreme Court of the UK held that the extraction and production of fossil fuels inevitably leads to emissions, and that is so clear that it must be taken into account before any further approvals of fossil fuel permits are given. And we had that echoed a similar judgment that was issued earlier this year in Norway, invalidating permits for oil and gas fields on the grounds that they failed to consider the inevitable and foreseeable climate impacts of producing that fuel. And so I think what we're seeing across the board is a reinforcement of the legal parameters for what conduct is acceptable, a reminder that states and corporations cannot continue business as usual and have to bring their conduct into line with what science and justice require. I want to mention the last place I'll leave off before passing it on, and we'll come back to this maybe in the later part of the conversation, is that we're in this historic moment not because of these cases at the regional and national, at the national and regional levels, but because we are in the midst of a triptych of advisory opinions. 3 different international courts have been asked, not just by communities, although supported by movements from communities, but by countries themselves, to clarify what international law requires of states in the face of an escalating climate emergency and mounting climate harm. And that was in the form of 3 requests. The first to the International Tribunal for the Law of the Sea on behalf of COSIS, the Commission on Small Island States on Climate Change and International Law. And that opinion came out already this year in May in a very historic judgment that I can hopefully turn back to and unpack for us a bit. And we also have 2 pending opinions that are forthcoming from the Inter-American Court of Human Rights, and that was requested by Chile and Colombia. And that is an opinion to clarify what the American Convention on Human Rights and human rights law requires of states. And that those requirements extend not just to what states can and cannot do, but how they should be regulating corporations and private actors within their jurisdiction and control, because we know that the climate crisis is principally driven by private action by companies and industries that are big polluters. And finally, and perhaps most significantly, the International Court of Justice is in the midst of reviewing arguments and about to hear oral hearings in an advisory opinion on climate change that was requested unanimously from the UN General Assembly. And I know my colleague will go into a bit more how that came to be, but this is a truly historic moment, for climate litigation and accountability, because we are about to witness the impact that these courts can have on cutting through the political inertia in these halls and reminding states and corporations that they are accountable not only for negotiated political deals that can be diluted or watered down or obstructed, but to law that no one is or should be above, and that there will continue to be communities that turn to and use these courts to enforce that law. So I look forward to unpacking some of those advisory opinion processes further in the panel. Thank you.
Fantastic. Yeah. Yeah, I think it's a very, very timely reminder. I wish we could broadcast this everywhere, everywhere in this building, that in fact countries cannot negotiate their way out of their legal obligations. So I think that is a big takeaway, and yeah, we hope people are listening. So thank you very much, Nikki. I would next like to pass on to August Dwi Hastutik from WALHI, Friends of the Earth, Indonesia. And she is the International Relations Coordinator of WALHI, and she works on the case against one of the biggest climate polluters, the cement company Holcim. Extremely exciting case. I feel like I have to say, I've been to Pari Island, I visited it, and the community there is one of the most inspiring people that I have had the good fortune to meet. And so, August, please.
Thank you so much, Kirtana, and thank you so much, everyone, for being here. My name is Agus. I'm with WALHI, Friends of the Earth Indonesia, and I'll just Sorry for the technical problem. I will talk about my country, Indonesia, who is facing a serious impact of the climate crisis. As the biggest archipelago country in the world with more than 17,000 islands, one of the biggest tropical forest countries, and also located in the Ring of Fire, the impacts of the climate crisis felt by communities in Indonesia are diverse. But in these sessions, I would like to talk specifically about small islands. In this case, Pari Islands, a small island located in the northern part of Jakarta. Yeah. So the Pari Islands is a small island located in the Thousand Islands. It is an islands group which consists of 110 islands, which 6 of the islands have already submerged into the sea in the past decades, and 23 other islands are threatened to submerge, including the Pari Island. And what is this about? In January 2023, the 4 plaintiffs from the Pari Islands, they are Asmania. She is a fisherwoman who is also the leaders of women group in Pari Islands. Mustakfirin, or usually called Bobby, a fisherman who is also the leader of Pari Island Care Forum. Edi Mulyono, a fisherman and also the leader of community-led tourism in Pari. And lastly, Arif Pujianto, a fisherman and also a carpenter in Pari Island. They filed a lawsuit against a giant polluters, a Swiss-based salmon company called Holcim. The reasons why they are filing lawsuits against Holcim is because the Pari Islands community, whose livelihood depends on tourism and also fishing, has suffered the devastating impact of the climate crisis. The plaintiffs and their families are confronted with rising sea levels, recurring tidal floods, and also increasing water temperatures. With the constant rising sea levels, right now about 11% of the islands have submerged into the sea. This event have led to, among others, the damages of their houses, the cancellations by tourists, decrease of fish stock, and also salinizations of groundwater. In addition to that, it also has led to bigger concern on how to put food on their table today and how and where their family will live tomorrow due to the constant rising sea levels. Why Holcim? Why are they filing lawsuits against Holcim? I don't think that we talk enough about this. But the salmon industry is one of the most polluting industries in the world after fossil fuels. Holcim is one of the largest salmon companies in the world and one of the carbon majors who bears a substantial degree of responsibility due to its high emissions. Scientific data shows that Holcim has released more than 7 billion CO2 from 1950 to 2021. This is more than twice of what the whole country of Switzerland has produced. Holcim's current climate targets are also far from sufficient to achieve the agreed agreement on the Paris Agreement to limit global warming up to 1.5 degrees. Therefore, the plaintiff, Asmania, Bobby, Eddie, and also Arif, have resorted to Swiss court, where Holcim has its headquarters. They have filed a civil lawsuit based on the legal notions of personality rights. They are saying that the impacts of the climate change, the climate crisis, have led to violations of human rights, and Holcim has contributed largely to it. Therefore, they should be responsible. The plaintiffs are demanding for 3 things. First, to reduce its absolute for Holcim to reduce its absolute and relative CO2 emissions by 43% until 2030, and then to contribute to climate change adaptation measures on Pari Island, and the last one, partially redress the plaintiff climate change induced damages. This case, however, is hence at first to adopt a comprehensive approach to climate change. addressing mitigations, adaptations, and compensation for loss and damage that has already materialized. So what are the progress that has been made since the lawsuit was filed by the plaintiff? In October 2023, last year, the plaintiff were awarded with legal aid by the Swiss court, but they are still waiting for a decisions on admissibility. Holcim has been delaying the proceedings by focusing on admissibility aspects and preventing the plaintiff from discussing the merit of their case. They expect a first admissibility decisions toward the second trimester of 2025. The plaintiffs are supported by WALHI, the Indonesian Forum for the Environment, HECS in Switzerland, and also ECCHR in Germany. The role of us as an NGO is to support their call for climate justice through public campaign call for climate justice.
Thank you very much, August. And we will come back to the importance of that and all the different aspects of climate injustice, the impacts and adaptation and loss and damage that this case is dealing with, which is very big. And now I would like to pass to Nina de Pater from Milieudefensie, Friends of the Earth, Netherlands. And Nina is leading the court case against the oil major Shell, where maybe you know that just over a week ago, there was a decision from the Court of Appeal in the Netherlands on this groundbreaking case. And Nina will tell us.
Yeah. Thank you. Yeah, just over a week ago, we were here in court, and the judge made it or read out its decision about the appeal. A couple of years ago, we started this court case, and we asked the judge to force Shell to reduce its emissions because of dangerous climate change. Shell causes dangerous climate change with its enormous emissions, more than several countries in this world, including the US, Russia, China, and India. Well, last week was the moment of truth. And although the court was not able to decide on one specific reduction percentage, there's a lot of stuff in this appeal ruling that is significant and that I would call a breakthrough. I'm going to take you with me through those breakthroughs. First of all, some quotes from the judge. There can be no doubt that protection from dangerous climate change is a human right. Climate change is one of the most pressing issues of our time. Well, we already heard this from other cases, so that should not be a surprise. But every time a judge confirms this, it helps the whole movement to build stronger cases. And she did something very, very important, because she also said companies have a responsibility when it comes to human rights. So that's relevant for the Holcim case, but also for other cases. And there's something else that she said. It's a bit of a long quote, but I will still read it because it is a significant one. The Court of Appeal is of the opinion that companies like Shell, which contribute significantly to the climate problem and have it within their power to contribute to combating it, have an obligation to limit CO2 emissions in order to counter dangerous climate change, even if this obligation is not explicitly laid down in public law regulations of the countries in which the company operates. Companies like Shell thus have to have their own responsibility in achieving the targets of the Paris Agreement, which basically means that Shell has an obligation to reduce its emissions. So those were the quotes, but of course there were many key takeaways to take from this ruling. As I said, Shell and other companies have a responsibility, a duty of care of their own to respect human rights and prevent dangerous climate change. Many companies say that they don't have this obligation towards our basic human rights because those are conventions between states. This proves this differently. Another key takeaway is that Shell is obligated to reduce its emissions throughout the entire value chain. So that means not just from production, but also from burning the fossil fuels that Shell sells. In technical terms, you call them scope 1, 2, and 3. And then a third takeaway And there are more, but I have limited time, so I chose the most important one. Shell's plans for new oil and gas projects are most likely at odds with the Paris Agreement goals. We see all around the world that people are fighting the expansion of the fossil fuel industry, specific projects, and the judge confirmed that this is not in line with the Paris Agreement. And she also confirmed that this is a problem when you take into account carbon lock-in effect. Because if we start drilling for this oil now, we are bound to do that for a very long time, which basically means that the fossil fuel industry is keeping itself alive. Of course, we hoped for a reduction obligation, but this is still a big success. And it's not just a success because it was something that we did in court, but it is a case that was brought by many, many people. We were with a lot of organizations. Some of them are here in the room. Actually, I already saw their faces. Greenpeace, the Association for Protecting the Wadden Action Aid, both ends Fossil Free, and Friends of the Earth Young. And maybe even more important, there were more than 17,000 individual co-plaintiffs that joined this case in first instance, which shows that it is the people versus the fossil fuel industry, the people versus Shell. And without these people, we would not have been able to do the work that we've been doing. Later in this session, I will discuss what it all means for us, for other cases, and I will also talk a little bit more about the meaning of communicating about these cases.
Thank you, Neen. I'm sure. Yeah, I'm sure everyone is dying to ask questions of all the panelists, so we'll make sure that we have time there. I certainly have a lot. And now I would like to pass to Jule Schackenberg, who is the interim executive director of the World Youth for Climate Justice.
Thank you so much. Is this loud enough? Okay. Yeah, thank you very much for the invitation. We always feel a little bit like the odd ones out because an advisory opinion is not strictly a litigation, but I really do appreciate the invitation. And of course, this is about legal clarity and accountability and remedies. So it goes hand in hand with the incredible work that others are doing. And I thank you and respect all of that very deeply. I'm with World's Youth for Climate Justice, which was inspired by the Pacific youth who initiated and championed the ICJ, the International Court of Justice advisory opinion on climate change and human rights, in short, the ICJAO. This started in a classroom in the South Pacific. Of course, this has been a legal pathway that a lot of lawyers have been speaking about for many years, but there was never really the political momentum behind it. And now with the Pacific youth, we really had the social legitimacy and the political legitimacy to take this forward. So really, they should be sitting here, but they're already in The Hague preparing for the hearings, which are due to start on the 2nd of December, so right after this. So I'll try my best to fill their very big shoes. It was in 2019 that they were in the University of the South Pacific. They had an assignment to come up with a legal tool to fight climate change, and they had read about this potential to take a non-contentious case to the International Court of Justice. And they managed at incredible speed and with a very high degree of community involvement to rally over 1,500 civil society organizations behind them. And they had reached out to the Vanuatu government, and the Vanuatu government, together with other Pacific states, has championed this ever since. It was, of course, a very difficult process to formulate a legal question that could then be included in the resolution that the UN General Assembly voted on and then sent to The Hague. So there was a lot of negotiation on what are we actually going to send to The Hague? What kind of climate change case do we want to see in front of the court? An advisory opinion is an answer to a legal question, and the legal question was the difficult part, but they give clarification and guidance to all states, so not just those who would be involved in a contentious case between two countries. So This was a very strategic choice to go for an advisory opinion, which is not strictly legally binding, but the advice that they provide, the clarification, applies to all states. So the question that the ICJ is going to look at in a week's time consists of two parts. The first is on a legal obligation. So it's asked the court to clarify what, I'm simplifying here for the sake of the understand, so that non-lawyers can understand. The first part of the question is, what obligations do states have in respect of climate change? And then the second part, potentially more important for the people in this room, is what, and that's where the climate justice piece of this case comes in. What are the remedies, the consequences if states don't meet these obligations? And especially in these holes, as we're seeing that this process is, as important as it is, it's simply not delivering for the Pacific students in the classroom in Pacific Islands, those most affected. We are looking at taking out kind of countries, as we had heard, countries can't negotiate here what they might want to do voluntarily, but there's these legal obligations. And so this case really has the potential to take all of this from the voluntary space and strengthen the negotiations in this process and clarify that countries have legal obligations to remedy and pay reparations and to pay up, as we've been hearing for weeks. So I'll leave it there, but happy again to come in on how all of you can be a part of this, because this is from the beginning been a civil society-led case. So this is all our case once we reach the Great Hall of Justice in just a week's time. And it really, I know there's a lot of supporters in the room who have supported over the years, but we really appreciate everyone's continued involvement in this, so that once it comes out, we can go back to our respective governments and use this to hold them and the polluters accountable. Thanks.
Thanks very much. So I have some questions here which I want to ask. I would like to ask and give you, but one is just occurred to me, which maybe all of you are thinking, and I think all the three of your presentations was tied together by the fact that it was really driven by a community of people, of climate justice campaigners who wanted to make this happen, who are looking for new avenues, and the importance really of representing these people, this community, whether it's the Pari Island fisher community or youth, in a more global sense. So maybe I will first ask the question to Nina, but then all of you can contribute if you like to talk about, the kind of work that goes around the case, because of course the case is key, it's pivotal, but everything that goes around it in terms of building a movement for climate justice is also very important. So I don't know if you want to say something.
I think we can all comment on that, but I can kick off. I think if you want to make a court case successful, you have to make sure that it comes from the people and that it is combined with a very good story, and not a story like a fairy tale, but a true story, something that we are striving for, that we are fighting for. From the beginning, we realized this court case will take years. We don't have years. Shell should have started reducing its emissions a long time ago and didn't. So basically the last resort was going to court. But at the same time, we also knew that we needed to break down Shell's social license to operate. And I think a court case is also a way to open the debate. In court, it is about facts. Shell cannot hide, and Shell and other companies or countries in court, they cannot hide behind green stories, because it is about the actual numbers. So that's what we always try to do. We always try to combine the court case with interventions in the public debate, and not just us as organizations, but we did this with all of the people that support this court case. I should have included the picture of us delivering the summons to Shell, because we went to the headquarters with a couple of hundred co-plaintiffs during a week day. So people were supposed to be at work, but took the day off to deliver the summons with us. And it shows that these people are really committed to the court case. A lot of them were also there last Tuesday in The Hague. So we were all there together when we heard the outcome of the appeal. I can go on about this for a very long time, but maybe I will pass the microphone to someone else now.
Yeah, if any of you feel free to come in if you want, or I will go ahead.
Thank you. Solomon Yeo, one of the founder of the Pacific Island Students Fighting Climate Change, he always said that the ICJ should pay us because we're doing so much PR work for them. I think a lot of people, I mean, this has changed within the past year, but before that did not really know what the ICJ was. How does it affect communities on a grassroots level? And I think I sometimes still struggle to answer that question. How has that court delivered for the people? But we have in the process, and all the partners involved in this case, in this very big alliance, have done a lot of work on explaining what the ICJ does, how it can affect what happens to you on a national level, also in relation to private companies. I think that public education piece is so important. And I think the Pacific Island students have always done an incredible job involving the communities, going back to the university, and really explaining how this diplomatic campaign that Vanuatu is leading, how this is a campaign for the entire country. And I was just received some photos as well from Port Vila, where there was women from the community standing with banners that read climate justice at the ICJ, and this was just this week. And they won't all be able to come to The Hague, but they still feel like they're a part of it. So to increase ownership, as tedious as it is, but these community workshops are just so incredibly important. The Pacific students have done music videos to also appeal and communicate the message differently. So I think, yes, of course, it's important to work with the lawyers, but potentially even more important to work with the non-lawyers and do a lot of the different outreach and communication work. So I do encourage everyone to check out the work that they've done and all the partners on this case. It's truly incredible.
Thank you. And August, I wanted to tell us, you told us the whole same case is ongoing, let's say. So can you say a bit more about the progress that's been made so far in the lawsuit, and maybe the importance as well of the other issues that you brought in? So the loss and damage part, which I think would be very interesting for several people.
Thank you, Kirtana. Yeah, as mentioned before, that the latest development on the case is in October last year, the plaintiff were awarded with legal aid, meaning that in the process of these litigations, this transnational litigation, the plaintiff do not have to pay for everything throughout the process going ahead. But I would like to talk, in the bigger umbrella, because this lawsuit is actually a breakthrough in Indonesia, and has been very important. The case of Pari Island lawsuit is the second transnational litigations in which the plaintiff from the global south are suing the global north carbon majors for its contribution to the climate crisis. So this is following the case in the Peruvian farmers filing lawsuits against German RWE at the regional court in Essen, Germany. The Pari Island case further demonstrates the global aspect of the climate justice. Through their legal actions, the four plaintiffs, Asmania, Bobby, Eddie, and also Arif, are demonstrating that it is very possible to hold the largest carbon majors accountable, while also highlighting that those most impacted by the climate crisis are already experiencing its severe effects. The case further illustrates that climate justice goes beyond simply reducing CO2 emissions. It also involves providing remedy to those affected and supporting their needs for adaptations and also mitigations. This lawsuit also highlights a fundamental injustice of the climate crisis. We all know that the reasons we are in these situations of the climate crisis is because of the long-standing exploitations that has been done by countries in the global north. And those who contribute the least, including the Pari Islands community, have to bear the responsibility of it. Therefore, I do think that it is imperative for all of us here to listen to the voices and demands of the affected communities to make changes, especially in the context of loss and damages. And in Indonesia, I think we should also talk more broadly of these loss and damages. It is crucial to recognize it extends beyond just property damages. Like loss and damages should not only cover about property damages. It must also be viewed through the lens of human rights violation as well, because in Indonesia, as mentioned before, that every landscape, every regions suffer different from the climate crisis. And we have seen a lot of people, communities have died, because of the changing climate. Many fishermen in Indonesia every year, they got lost into the sea. They died, and many of our farmers, they have to suffer from, you know, from ecological disaster because of the landslides that is also caused by the changing climate. These issues are not. These issues should also be included when we talk about loss and damages context.
Yeah, thank you, August. And it relates very clearly, I think, to what some of us are seeing happen here, where while we say from civil society that the issue of climate debt and loss and damage, it's almost impossible to put a number. It would be in the trillions. In fact, it is. And even the estimates of the UNFCCC are like up to 10 million. But what's being put on the table here is so negligible, or nothing at all. And we need new ways. We need new ways to, I think, make this kind of more, more legally binding, I would say. I think what probably all of us, I'm guessing what you're all thinking, so I'm asking you a few questions, but I will stop very soon because I'm sure you do have questions yourself. But one thing I'm thinking, which perhaps a few people are also thinking, is actually, can you tell us why this matters? What can we do? What can we expect to hear from some of the advisory opinions? Maybe Nikki, I don't know if you can talk to that, and also Yula, what can we expect to hear? Maybe why is it significant? What can it mean for us? In the work that people are doing elsewhere in the world, and also what does it mean here? Perhaps next year we can hope for better.
Sure. I think maybe just to start with something in response to that, but with something that Yula said as well, and distinguishing these advisory opinions from contentious cases or litigation, even though these are not cases between two or more states resolving a specific dispute. As Yula said, they are authoritative interpretations of international law, and that statement of what the law requires will inform courts around the world, and it direct and inform states and corporations that have legal duties as well in terms of what kind of climate action they take. And this isn't just abstract. We've had a recent illustration of the power that an advisory opinion can have in the case of the Chagos Islands. So a case challenging British colonial administrative control over an archipelago over which Mauritius claimed sovereignty. And this was an advisory opinion that came before the ICJ several years ago, but it also illustrates the importance of, in these cases, of there being a movement not only to feed into and inform what courts are hearing about the facts and the impacts and to tell the story of a case, but to receive the opinion and to use the legal tools that it provides. And in this case, there was an opinion issued in 2019 that concluded that the continued control by Britain over this archipelago, not ceding recognizing its self-determination and ceding sovereignty, was unlawful. And it took some years, but there's been a longstanding movement and pressure. And so this movement for the rights of Chagosians and for independence and sovereignty prevailed. And just in October of this year, the UK relinquish and recognize the sovereignty of Mauritius over these islands, right? So there's not always a direct link, but it can indeed impulse action. And that is one of the things that we hope that these proceedings at the ICJ, but also in the Inter-American Court and the ITLOS decision that I wanted to mention a bit, can inform the ambition and the scope of climate action by the states that are gathered here. It should hopefully make further litigation less necessary, right? By clarifying what is actually required, it will give greater legal weight to the rightful demands that many states are making of others and that we are making for more ambitious action and justice. But we saw already, just to flag a few of the really critical issues that are before these courts, the questions and how they relate here. We saw already in the opinion that came out in May from the International Tribunal for the Law of the Sea, sometimes known as the World Ocean Court, that concluded in no uncertain terms that greenhouse gas emissions are a form of marine pollution that states have an obligation to prevent, reduce, and control. And that obligation exists under the UN Convention on the Law of the Sea. It exists under the Law of the Sea. And why is that so significant for these proceedings too? Is it's a reminder, and the court was very clear about this, that states have obligations under multiple sources of international law. It is not solely the UNFCCC or the Paris Agreement that dictates what states can and should do about climate change, but ocean law, longstanding customary international law, and human rights law, among other sources. And so it's one of the big issues going into the upcoming hearings before the ICJ is precisely to affirm that the answer to the question before that court, which is what is required of states, what are their legal obligations in the face of the climate emergency, and what are the legal consequences, what's the legal impact on them and responsibility if they fail to uphold those obligations and damage ensues, as it clearly has, because we can see damage escalating around the world. That question, the answer to that question neither starts nor ends with the Paris Agreement. And I think it's very important because we have seen states go to great lengths to try to confine the scope of their duties to say, all we're required to do is what the text of the Paris Agreement says. And if you look at that text, the Paris Agreement doesn't actually require us to do much of anything. Maybe that's why so far we've seen these inadequate nationally determined contributions, these plans that year after year fall short, and that the states are saying, well, but it doesn't require us to actually deliver on the plan, just to produce it. We made one, we're trying hard. That's not a sufficient answer because whatever happens in these halls and the text of that agreement doesn't displace or supplant the longstanding and continued obligations of states to prevent foreseeable transboundary harm and to prevent foreseeable harm to human rights. And there is no question, as Nina underscored, as the court in the Netherlands and other courts, the European Court, many courts around the world have now recognized climate change is clearly a human rights crisis. It is having human rights impacts and it triggers human rights obligations. And that is something we're very much hopeful that the ICJ will come in and reinforce. And just to add one last thing before I cede the floor again, that the other critical question before the ICJ is that this is not just a forward-looking issue. This is not just, oh, what should states do now and going forward to make sure they comply with their obligations. This is also about recognizing that states have had to take action to curb the causes of the climate crisis for many years, and they have clearly failed to uphold those obligations. And that has consequences. Under longstanding international law, when you breach an international obligation and people are harmed, you have a duty to provide remedy and reparation. And that provides legal underpinnings for the claims that we're hearing in these negotiating rooms now. Countries are demanding money for loss and damages. They're saying, pay up, rich countries. And that is not just a moral appeal. That is a legal appeal. That is a legal duty. And so we're really looking forward to hearing the states that will be in the courtroom in The Hague in the coming weeks, who can't hide from their interpretations of the law there. It will be live streamed. And it will be, before the highest court in the world to hear. And we're looking forward to them tackling those issues and hopefully providing some clarity and affirmations that can give us all more legal tools that can instruct and empower courts around the world to interpret the law, to compel a change in conduct and to compel the kind of reparation that's overdue. Thanks.
Thank you. There's a lot of things to look forward to. And My last question, I promise, before I pass the floor over to you, I think is for Eula. Yeah, I mean, I think every kind of climate campaign that young people are doing is pretty inspiring, and this is particularly inspiring. And I think what is it? What can we all do? Yeah, also to support you in this. And again, if you have things that you think will happen in the follow up, what can we look out for? What should we look out for? What would the Pacific youth like us to? How would they like us to support them?
This is, of course, not to say I want to speak for them. In this case, it's really for all of us and the respective fights that you're fighting. Vishal Prasad from the Pacific Students always said that he wanted this case to be a home, or to be able to become a home for a lot of these other struggles. As hopefully this can close a gap, and these are not my words, but that this can close a gap in equity and ambition and fairness. And so this will help the respective cause that you're fighting within this. So together with a lot of partners, we've thought of different ways to get kind of the people's voices into the courtroom. There's a little bit of precedent for this having happened in the past, but overall, the process at the ICJ is quite limited. So it's states only. They only get 30 minutes to address the judges. That's not a lot of time. Not a lot of time for us to really be there and push for some of these more progressive but very clear legal arguments. And so there will be, we are working on, or we've put out a petition together with partners. This has happened before in the Nuclear Weapons Advisory Opinion, which was also a civil society-led effort in the 90s. They were able, and this was before we could sign petitions online, they were able to collect several million signatures, and they brought them in boxes to the court, which made for very strong images. And you can read afterwards in the outcome that some of the judges referred to these petitions, having recognized that the people's opinion is very clear on nuclear weapons. And so there is a petition on this as well, and we've asked countries to reference to this so that the judges and their teams are still pointed towards it. That's one piece. And while we understand that in 30 minutes, it's unlikely, although we are advocating for states to include their own people's stories, bring an Indigenous person, a young person, bring a person with lived experience to address the judges. There is an online platform for these witness testimonies. It's called the Witness Stand, where people can share these stories. And again, we've been able to request, or we have requested states to reference that in their submission, so that again, we are pointing the judges and their teams to an external source of lived evidence. So the witness stand is something that you can participate in, that you can spread in your respective networks, that people can partake in storytelling, the stories that we are pointing the judges to. And then there will be we used to call it the People's Hearing, and we've now changed it to a People's Assembly. So there will be a People's Assembly outside the courtroom to listen to some of the stories that won't have space within the courtroom. This could be because a state is not, a group of a community is not recognized as a state in front of the ICJ. Maybe the state and the community don't have a good relationship. Maybe the state is not friendly to including lived experience. And so for a variety of reasons, we're giving space for these stories outside the courtroom. So if you are near The Hague, if you are able to come, you can listen to these stories. And again, we've asked states to reference the People's Assembly, which will be taking place outside. Overall, and that's why our friends are already in The Hague organizing, there will be a variety of mobilization activities, which a lot of the partners, also some of who are in the room, have helped to organize, so that this will be an empowering experience for everyone who is coming to The Hague, especially if these are delegations, small delegations who are coming to The Hague, have to fly across the world to attend these hearings, that this can be an empowering experience for everyone involved. And I think, and for example, in the Atlas case, there was community testimony. I think it's the first day, where a young mother from Tuvalu got to address the judges, which had a very tangible impact on the judges in that moment. And I think because that was very clear, the outcome was very, very positive. And so we absolutely believe that the same can happen at the ICJ. And again, yeah, inviting everyone to be a part of that climate justice gathering that is being organized for the period of 2 weeks, because that's how long the hearings will be.
Thank you so much, Eula. And I think, I mean, obviously we've talked about a few cases now, but I just want to give a shout out that, you know, there are so many other ones. Long-standing case against Chevron by UDAPT, and, you know, across South Africa, and in many, they're formulated in many different ways, right? Against bad air quality, or against, you know, human rights violations. And but we hold all of these because they are all our cases. They're all climate justice. Climate justice is human rights, as some of our panels have said. And I think it's really important. And I think another highlight for me is that in campaigning terms, not in legal terms, because I'm not a lawyer, we talk a lot about impunity. Yeah, and we see it everywhere. Here, I mean, it's just incredible. For decades, some actors have been able to proceed with impunity. And I think if we have some hope that we can use these cases to actually stop that, that is a major win. So with that, I would like to pass the floor over to any of you who have questions, especially for the panel. I'm not sure that there's a mic, unfortunately. So I might check, but I don't believe that there is. So you might have to just, there is. Amazing. Thank you. So there's a question here, and
Yeah, thanks. Thanks for that those really inspiring presentations. I guess thinking specifically about the corporate accountability cases, and just wondering if the panelists could speak a bit to how you think about the risks of potential negative outcomes or directions, such as long procedural delays that delay justice, lobbying for immunity, bad settlements or bad legal precedents, and of course, just picking up on that comment there at the end, strategic lawsuits against public participation or attacks on human rights defenders, retaliation against human rights defenders. Thanks.
maybe we can take a few. Is that okay? So it's one here and then one.
Hello, I'm from the UK and I work with young people across the UK. And I've just been inspired by the cases you brought forward. And I really do hope you see the fruits of your labor and get some rest as well, because this work can be quite tiring. My question is mainly to Eula, just because I have spent the past year talking to young people who live in coastal cities and towns, people in urban areas, rural areas, and they're seeing environmental degradation accelerate because of climate change. And I think your case with your organization is just really inspiring to bring back to the UK. I wanted to ask, is this scalable? And are there ways for us to collaborate beyond COP29? I don't think we should wait for these yearly annual conferences to take action. It'll be really good to work consistently together. Thank you for your time.
Hello, my name is Maria. I am a PhD student at Cornell University. And I remember, like, in the public hearing before the Inter-American Court of Human Rights, there was an intervener who asked the judges whether they could make synergies with other courts to be as progressive as they can in their own respective advisory opinions. So I was wondering whether you are planning for the public hearing at the ICJ include some references to certain quotations of the International Tribunal for the Law of the Sea decision. Of course, I understand that they are like, bodies that are related to certain jurisdiction, treaty-based bodies, but maybe alluding to certain quotations could inform and could inform other, decisions elsewhere in other fora. Thank you.
There's a last.
Thank you. Hello, colleagues. Congratulations on the amazing work you're doing in the cases. Being in this global space, I want to ask, how do you see all the victories that are happening with tons and tons of cases of climate litigation that then have problems with implementation of decisions, we start maybe seeing something that could be similar with what happened with the climate negotiations, where people is reclaiming for human rights and more ambition, and at some point it seems obvious what is needed to do, but it keeps not happening, and judges all around the world are giving our communities reason on human rights violations, and even nature rights being affected by the climate crisis. But even though nothing's happening, so, or much is happening, but not as much as we want. And my question is, how do you think we can use those decisions in the local level, even with the problems in implementation in this kind of international spaces? Like, how can we bring the success of the cases to make another narrative in conference of the parties, for example? Thank you.
Okay, that was probably 4 questions, I think, but that's good. I think that's great. We have quite a lot to work with. I don't know if you need a quick reminder, because I think all of you could probably take, they were directed at people, but I think if you want to all respond, feel free to. There was something about the negative outcomes and the risks of bad decisions, but and also other cases that have happened on public participation. Would that be considered also as part of this group? There was a lovely question about collaboration, across countries to support youth, but I'm sure also others, and where and how and when can we do that? There was a question, if I understand right, about whether actually the legal system is able to work together better systematically, or is it, is it isolation? And if I get your questions right, there was one about the lack of implementation, which we know, we can see many times there is a huge history of 30 cases being agreed, and actually none of them happen unless there's political will in the end to make it happen. So that's very challenging. But also the implications of this process. Yeah, is that implementation? Okay. Yeah, sure. Okay, so whoever would like to start, shall we go in the line? Eula?
I leave the more difficult ones to the other panelists. I just pick what I feel comfortable and inspired to answer. Yeah, thank you very much for the question on collaboration. We're of course extremely open and extremely excited to do this. Of course, this is just a legal avenue, and I think this was never the end goal, but the implementation would be. And as Nikki has said, states have these legal obligations. Let's see what the advisory opinion, what the judges will find. But we know that states have these obligations, and we know that there should be remedies. And so we can continue pushing for that on a local level, on a national level. And I think it's about empowering children and young people, and of course communities in general, to say that you have rights, states have obligations, and you are entitled to a remedy if if these rights are not respected. And I think very excited in all countries where that's safe to do, of course, to work with young people and communities to do that. And we have indeed been approached by young people already saying, this is a bit too slow and maybe not radical enough. Can we do litigation now? And so we'll try our best to advise them already now. And then there was a question on ITLOS and how do you bring it back to a community level. And there was one of the lawyers involved in the Commission of Small Island States on International Law and Climate Change. I think it's in that order. And she jokingly said that they were thinking to print T-shirts that would say, all necessary measures and best available science. And I think with these 2 key pieces, that's something that non-lawyers understand. Anyone around the world can understand that states have to, and these are quotes from the judge, from the advisory opinion, have to take all necessary measures and use the best available science. And I think these are pieces we can take back to communities and ask and share with them to ask their governments to respect that. And that I think are also elements that I hope will find their way into the ICJ opinion. And we do know that states were reading that very closely, and we're weaving that into the written comments in the state of the ICJ. So if you are taking anything from this panel, then it's these two things that came out from ITLOS that are key that we'll all be taking with us to The Hague and then beyond.
And then I will take the other two questions. I think when it comes to negative precedents and precedent setting and backlashes, of course, there's different types of backlash. And first of all, you should never take a court case very lightly. I mean, it's a lot of work and a lot of preparation. So it also shows that if you don't put in the effort, then a court case might go wrong. But luckily, the evidence is building. And we see that the scientific evidence is on our side. And I also want to emphasize that a court order or a court ruling is almost never black and white. And I think that is often portrayed that way by media. Media really likes a winner and a loser. But then when you look at court rulings, there's all of these different arguments that are discussed, that are discussion by themselves. So even a court case that does not have the perfect outcome can be a breakthrough and can also help other cases. And we used a lot of arguments that were already put forward in other cases and that we could build on in our case. And I think that every case here can emphasize that. Of course, there's also another type of backlash that we encounter, and that is the opposition, the people that we are fighting, because they won't go down easy. So we see in our case the fossil fuel industry really fighting back, lobbying, and trying to reduce civic space. And that is also something that we should be aware of, but it does not mean that we have to take a step back. It means that we have to take a step forward, because it kind of shows their struggle also to maintain the system that we are trying to break free from. I hope that kind of answers your question. And just to add one more thing, we can really help each other. Because what I said, these court cases are a lot of work and they are sometimes very difficult. You can have very technical discussions with lawyers, with scientists, and how to bring them together within one court case where the judge can still understand what you're saying. And we don't have to do that by ourselves, because the climate litigation community is growing and there's so much expertise that we can learn from. And the question from the back. I just want to give a very concrete example. We already saw a huge impact of the Shell court case before the appeal ruling came out. In Europe, there's this new legislation called the CSDDD, the Corporate Sustainability Due Diligence Directive. It's always difficult with these type of long acronyms. Yeah. So this is a directive that was recently passed through the European Parliament, and it forces companies to have a climate transition plan and to take responsibility for human rights. And we spoke to one of the people that was involved with designing this law, and he literally said that our court case did push this regulation to become more ambitious. And this is just one example of how court cases can also have an impact outside of the courtroom. So I hope that gives you a little bit of hope. And it also shows that even in places like this, like a COP that is, I would say, a bit depressing, because we are talking and talking. I think none of us saw the daylight today or had some fresh air. So even within these type of spaces, we can have an impact with our court cases. So that's just one example, but maybe my colleagues have more. Thank you.
That's a great example. So I think, I mean, Yula, I think just want to lift up what a brilliant summary I think that was in many ways of the key things to take away from the ITLOS decision in response to how it's being leveraged and used and how the courts are talking to one another. And that's what I think is so beautiful about not only the series of advisory opinions, where I do think there's a real ability for courts to build on and reference one another, but we're seeing that happen throughout climate litigation around the world, you know, as the rapid evolution of cases in different countries where it's helping the law evolve even faster and courts, because there are similar bodies of facts and evidence. And to really hear loudly pronounced that states have to take all necessary measures, do everything within their power in accordance with the science to tackle this problem is something concrete that can be brought down to the local and national level as a test to assess whether action is happening. And it was also, because you referenced the Inter-American Court hearings, I just wanted to lift up how incredibly powerful it was in those hearings to have the voices of Indigenous leaders and community members, to have the voices of communities there in the courtroom. And it's wonderful that there are efforts being made to bring those voices either directly to the ICJ or outside, because I think you could see visibly, my colleagues told me who were in Brazil, but certainly in Barbados as well, that you could see that the judges are reacting to that. You know, we often think of courts as insulated from, you know, political trends or feelings or whatever, but they're human beings making decisions in these bodies, and these institutions are swayed also. And I think that's really important. But I wanted to just address the issue of backlash or blowback and the risks associated with litigation, because, you know, as many of you may have seen in the halls here, there was a lot of attention to the rising crackdown on environmental and human rights defenders around the world, the situation in which many journalists, civil society activists, community representatives find themselves facing, you know, physical harassment, intimidation, and violence, but also abuse of judicial process, right? Being arrested and detained. And another, you know, form of abuse of judicial process is not just against activists and advocates who have the courage to challenge power and demand justice, but also we've seen companies use what I like to refer to as a kind of international slap suit, which is where we've seen foreign investors suing states that try to take effective climate action in the form of investor-state dispute settlement. Some of you may have heard of this kind of arbitration that allows, and certainly the Netherlands has been on the receiving end of such cases, but not alone. I think, you know, the fossil fuel industry is the largest user of this unaccountable secret court system, really, secret arbitral tribunals that aren't reviewable, that allow foreign investors to challenge climate action or other environmental and public health measures when they claim it impacts their returns. And that provides, it has a really big chilling effect on the willingness of states to take the measures they need to deliver climate action. And so there are ongoing efforts to try to take that weapon, if you will, legal tool or weapon out of the hands of the big polluters. But I think in the face of SLAPs and procedural delays, we need to see increased efforts to get anti-SLAP legislation passed around the world. We've seen some steps forward, but we also need to see more and more appeals at the local level, at parliamentary level, and solidarity to lift up and provide protection through community to those who take on cases. And one of the best antidotes, I think, to individual cases facing challenges is really a proliferation of cases. It might seem counterintuitive, but this is why we need more resources to do this. It's one of the ways that we protect against a bad judgment here is that there are 3 good judgments out there, you know, and that there are complementary strategies being tried. So I think that's really important. And then the last thing, and I'll stop here, about Javier's challenging question about what do you do about the lack of enforcement or implementation, and how can they influence these proceedings? I do think that part of it is moving beyond seeking just declaratory judgments, and those are powerful and important pronouncements of what the law is, what rights are. but actually pursuing cases that address the underlying conduct that is really the culprit, right? So particularly fossil fuel production and use, where it's not a question of pronouncing that something is or isn't in accord with the rights, but it's stopping projects that are incompatible with human rights, with legal obligations, because I think that makes the effect far more concrete and has ripple effects on investors and it touches the pocketbooks of these companies and can stop the harm. But yeah, I will leave it there for now. Yeah.
Thank you so much for all these questions. First of all, I'm not a lawyer, so I won't be able to answer all the first questions. But I would like to add the context and the slow progress and and the outlook going forward, especially in the case of Holcim. So the current situation right now, Holcim is trying to discredit the lawsuit filed by the communities by saying that this is not the communities doing, but this is the NGOs doing, which is not true because these communities have felt directly the impact of the climate crisis and they decided to go to Swiss court, to filing lawsuits against Holcim. And even, we have seen some development, even though we are still stuck on the admissibility, but the Swiss court have decided to provide legal assistance for the communities. So it is expected that the court will take a decisions on the admissibility next year on the fall. And if the court decides that the lawsuit is admissible, then Holcim will most likely file an appeal. And this means that the lawsuit will go to the higher court and after that to the federal high court. And if the first court decides that the lawsuit is not admissible, the plaintiff have the opportunity to appeal the decisions all the way to the federal high court. And the decisions by the federal high court could be expected roughly in 2028, which is 4 years from now. And if the federal high court also rules against the plaintiff will have the possibility to go to European Court of Human Rights. So going forward, we see that this is going to be a long process and decisions on the merits, the substance of the case. This is on the questions whether Holcim has obligations to reduce its emissions and to pay for the plaintiff for the compensations and also for adoption will most likely take years from now.
Thank you all. We still have 10 minutes. So we could do another round of questions. I'll probably only take 2 or 3 this time. Kolvani.
Okay, so the question is, to what extent will we at some point take our own governments and the multinational corporations to court? Simply because some of the governments really do want to implement climate action within their own countries. However, the multinational corporations are the one abusing their power over our governments because of past sanctions that have been made to certain countries. So that's the one question. The other, it's more of a statement, is to say that I think as activists, we do need to acknowledge and recognize that the legal system is, or the legal tool or instrument is also a solution to some of the action that we are doing on the ground as activists. Thanks.
Any other questions? This.
Hi, this is Johan with Quaker United Nations office. Thank you all so much for your incredible work and really inspiring words. One thing I was noticing, and you all brought up as well, is just sort of the long pipeline of all of these cases. And a lot of them, it's great to see them getting their day in court now, sort of as the current generation. But I'm curious sort of what's next, and what do you see both in terms of sort of ways to build and think creatively about legal processes that might come in the future, but also in terms of movement building. And sort of what's the next generation of cases look like?
Maybe one last. Anybody has a burning question? No. Okay. So maybe we'll go through the panel again to maybe we have 8 minutes, so a couple of minutes each. And also if you have any closing remarks or things you really like, key points you wouldn't like to leave the room with, then please go ahead. We'll start from this side. Yeah.
Okay. The lawsuit on party aliens that have been filed by Asmania, Bobby, and also Eddie and also Arif are a call for climate justice. They are demanding the Swiss court, the global, polluters, to recognize their reality, protections of their rights, and also compensations for the loss and damages that have been felt by the people in Party Island. This is maybe not directly answering the questions, but what I would like to emphasize for us as civil society, for us activists, as human rights lawyers, and many groups who are in this movement, we should always seek the responsibility of our government and also do not let them to plunder. We should continue to call those big polluters to be held responsible to reduce their emissions, because the longer the major those companies delay taking responsibility for their role in the climate crisis, the more they will end up paying, and also the greater the challenges that we will face in the future. And I think we have now reached or even gone beyond the point where these companies must pay for their carbon emissions and to be held responsible for the loss and damage and also reparations that they have caused due to its high CO2 emissions. Yeah. Good.
Those are great questions. I think maybe just a couple of thoughts, won't be remotely comprehensive answers, but I think that in terms of the long timeline of cases, and if I understood right, the question, one of the, I guess there are two things that come to mind for me as kind of counterweights to that. One is that cases aren't only about the final outcome or the judgment, right? And I think that it just underscores how important it is, the process of the movement behind the cases and the process of actually building and participating in the case through this, strategic communications and organizing around it, through the testimony that's brought to bear, through discovery, or the equivalent in other countries where you can get information even before, from the parties to the case, even before a judgment is issued. And it can be an incredibly powerful mobilizing tool. And sometimes the reputational risk on the defendant or the public pressure and the storytelling can actually have farther reach. But it can also be really a training ground, I think, for many lawyers. I'm sorry, scratch that. Yes, it is a training ground for lawyers. I meant to say a training ground for many leaders, community members, the people who participate in this, who get to have the experience of telling their stories and understanding the power of their own expertise and having that recognized and that perspective, and really they're becoming the leaders, if they're not already, of the solutions. And I think that's really powerful. And the longer these cases drag out, the more the facts are on the side of the plaintiffs, right? I think that's a tragic reality, but the truth is that the cases just get stronger, I think. That doesn't address the fact that we need more urgent remedy now, but And in terms of some of the next generation of cases, I do think there's a critical need to look beyond just the governments and the biggest polluters to those who are bankrolling them, and to bring these legal challenges to the banks and the investors and those who are financing this destructive conduct, and who, as you say, are the corporations that are really capturing policy spaces and capturing governments. And we see that at play here in the COP with the high number of lobbyists around these halls. And we need to, be focusing on how we crack down on that conflict of interest going forward, and the tools of greenwashing that they use. But there's lots of creativity in this space and around the world to have wins along the way. Yeah.
I think that was the perfect bridge to what I was going to say, because we, in terms of next steps, we already announced our next case, and it will actually be against one of the biggest banks of the Netherlands, or the biggest bank of the Netherlands. That is also the financing a lot of fossil fuel companies, and in terms of emissions that are related to the financing of this bank, that is incredible. So we are already taking this step to also go after the enablers of pollution. Another thing that I think that we should keep our eye on when it comes to climate litigation is those cases like the Holcim case, because I think we will see more and more cases that are brought by people in the south towards companies and governments in the north. So keep an eye on that. And I think just to answer to your question, to what extent are we willing to go? And I think it should be made very clear that we don't want to go to court. It is not something fun to do, but we have to, because companies and states are failing us, and they are failing to regulate these big corporations that are continuing making profit over our planet and over people. So we know that it takes years, and we know that there's much more that we need to do, but we also have to go to court just because we cannot do anything. We cannot not do it. So maybe to conclude, and then give the final word to Julia, is that the climate movement needs court cases, but court cases need the climate movement even more. So I'm also calling to all of you, keep doing what you're doing, and only that way we will be able to succeed and win more cases. Thank you.
Yeah, maybe just leave you with one final call. If you are a funder in the room, then we cannot take cases without the funding. And I think that's where the hurdle really is. People want to take these cases. There's innovative ideas, the minds are there, but without being able to compensate those doing it fairly and to fund some of these public engagement activities, yeah, it simply can't happen. So just leaving you with that forward-looking point, the invitation to fund. Thanks.
Right. Thank you, everyone. We are bang on time, so it's definitely a panel of legal people and not activists. But thank you so much. I see a lot of tired faces, and thanks to our extraordinary panel. And I think my one takeaway is that we all know that we are living in very, very difficult political climates in many, many countries. And the justice system is a key part of a functioning democracy. And so while these cases are focused on one thing, they are also actually, I think, ensuring that there's civil society and public scrutiny on that pillar of democracy, which we absolutely 100% need at this time. So thank you for all the work that you're doing, and thanks to all of you.
Dear guests, please don't forget to get all your belongings, since it's the last final session. Thank you.